I'm Jan Painter, and I'd like to welcome you again to our program, Politics Matters. Our guest today is Professor G. Edward White, who has kindly agreed to return with us to continue our discussion about the Supreme Court. Professor White is David and Mary Harrison Distinguished Professor of Law at the University of Virginia. Professor White holds a BA from Amherst College, a PhD and MA from Yale University, and a JD from Harvard Law School. Dr. White became a member of the UVA faculty in 1972, having clerked for Chief Justice Warren of the Supreme Court. He was twice a senior fellow of the National Endowment for the Humanities, a Guggenheim Fellow, a fellow at the Society of American Historians, and a member of the American Law Institute. Professor White is the author of 14 books and numerous articles on law and legal history. He has won an impressive number of awards and honors, including a final listing for a Pulitzer Prize in History. His many books include History and the Constitution, Collected Essays, The Constitution and the New Deal, and The Marshall Court and Cultural Change, 1815 to 1835. Welcome again, Professor White.
Thanks.
Professor, last time we were discussing the original structuring of the Supreme Court as referenced by Article 3 of the Constitutions. We were talking about the duties and responsibilities of the original justices, and most particularly the appointment by John Adams of John Marshall to be our fourth Supreme Court justice. And this in turn leading to the landmark case Marbury versus Madison in 1803, which first allowed the court to overturn a law passed by Congress if it was deemed to violate the Constitution. Thus, we introduced the role of the High Court into judicial review for the first time in our history. We talked about the subsequent back and forth, the contentious arguments which took place between Jefferson and Adams over the relative importance of the Federalist versus the Republican point of view. Define for us again, if you would, Professor, the distinction between federalism and republicanism as it was understood in the late 18th, early 19th century.
Well, the distinction starts with Washington's administration. In the last phases of Washington's administration, Alexander Hamilton and Jefferson emerge as spokespersons for different theories of the relationship of the federal government to the states. Hamilton basically taking the position that there should be a strong, aggressive federal government with a fair amount of control over state affairs, Jefferson taking the position that state autonomy was more important. And these political divisions eventually surface in the form of different political parties, so that by the time that John Adams becomes president, and for the duration of Adams' presidency, Jefferson is in effect a leader of the opposition. And then in the 1800 election, Jefferson challenges Adams. And he actually describes a political party that he heads as the Republicans. Adams is running as a Federalist. It's a close election. It's thrown into the House of Representatives, and Jefferson wins. That means for the first time in American history that we actually have a partisan change in American politics. So the Adams administration leaves town, Jefferson administration takes over, and before Adams does, he makes a number of appointments to the federal judiciary, including John Marshall to the Supreme Court. So when Jefferson begins his administration, the division between Federalists and Republicans is in place.
Okay. As we saw last time with the Federalists prevailing over Jefferson, we were discussing this sort of pamphleteering and the back and forth issues and the controversy that ensued. Tell us a little bit about the ways in which information was disseminated to the public at that time.
Well, one has to remember in this period that although there are newspapers, and although newspapers circulate, the modes of communication are limited. It takes a long time to get from one section of a country to another. And so another way in which Americans, and of course there's also no other sources of information. I mean, we don't have television, we don't have radio. So another way in which Americans get information is through local pamphleteering. And what emerges in the period against the backdrop of partisan conflict are anonymous, basically printers, people who own printing presses, who then become, we would think of them as the equivalent of bloggers today. They're issuing pamphlets on a variety of issues. And they usually don't sign them by their names. They usually sign them, they usually make allusions to classical. They'll call him Tacitus or some figure from the classical period. And this pamphleteering is going on for almost the entire time in which when the Marshall Court is organized. That is between 1801, when Marshall starts, and 1835, when he retires. There is constant pamphleteering, critical of the court, critical of the administration that goes on.
Now, when you were mentioning the references to Tacitus, would this presume that the people looking at the pamphlets were, learned? Was that a privileged number of people, therefore, that were reading them?
Yes, of course. Many people in the country can't read at all.
Right.
The educational system is fairly limited. So these messages are circulated to elites, but then they're disseminated from elites to others. So that people will read the pamphlets and talk about the issues, and that's how other people in the population will become aware of them.
One of the things that I thought was very interesting in reading your book, you talked about the fact that at this time there were no written briefs. Decisions that were made by the court were oral, and therefore people didn't necessarily hear a great deal about the decisions of the court.
Well, first, as to the briefs, the court did not have a requirement that lawyers who argued before it submit written briefs. They would often submit a one-page summary of their argument, but even that wasn't required. So one of the differences between the modern court and the Marshall Court is that the justices are taking notes while the lawyers argue. And part of the reason they're taking notes is because the lawyers are presenting them with sources for their opinions, which they're not getting in any other fashion. Now, as to the dissemination of the court's opinions, there is a reporter for the court. Originally, this is a private entrepreneur who just decides that he will report and publish the court's opinions and try to make some money off it. Beginning in 1815, the court gets an appropriation for a salaried reporter, and from then on, the reporter is paid. The reporter is charged with taking opinions that are in draft from the justices, handwritten, and editing them, providing additional support, footnotes, and so on, and then publishing them in reports that bear his name. So Henry Wheaton is the reporter for some of the Marshall period. The reports come out as Wheaton's reports. They don't come out contemporaneous with the actual release of the opinion. The court meets in a limited period from January to March, and they hand down opinions. Sometimes the text of those opinions will appear in newspapers. But more commonly, the text will not be reported, and it will not come out until many months later when the U.S. opinions are published. And the people who read those opinions are a very limited number of people.
I see. It's fascinating that a reporter would be involved in this process. I can't imagine that today. You mentioned another thing after we filmed yesterday, last time, about the fact that the justices really had very little weight of precedent before them, that they were freer than almost any other period after that to make law. There are obviously advantages and disadvantages to this from the point of view of a justice, the justices on the court. Do you feel today, for instance, that our justices are somewhat overly constrained by the weight of precedent? What's your feeling about that?
There are just many more published decisions of the court. In the Marshall Court period, first of all, you don't have a long history of court decisions, but you also don't have a lot of published decisions. So many cases that the Marshall Court decides are raising issues for the first time. Of course, the modern court has a long history of precedent.
Exactly so.
The current court is self-conscious about precedent. Indeed, it's now become fairly common in cases where the court is overruling a previous decision. Citizens United is an example, the case involving campaign finance, corporations' ability to have unlimited expenditures. The court's justices take some time in that case to say why they're overruling a precedent and how much weight they give to precedent. Marshall Court justices don't do this at all.
Interesting. So the Marshall Court, we know, resulted in a somewhat larger footprint with respect to the powers of the court. The federal government is the guardian of the law. The subsequent court, the Tawney Court, how did Justice Tawney react to the Marshall Court? Did he share Marshall's views? Did he diverge?
Well, first of all, he certainly doesn't share Marshall's views on the major issues, constitutional issues of the period. I mean, Marshall is an advocate of federal power. Tawney is a strong advocate of state power. The Tawney Court, from almost the beginning, is affected by the relationship between slavery and westward expansion. This is the period, Tawney's on the court from the 1830s to the 1860s. He's still on the court when the Civil War breaks out. His appointment was in 1837. That period is a period in which there's considerable westward population movement, and which it's discovered that slavery has the potential to flourish in the Trans-Appalachian and Trans-Mississippi West, or at least in some sections. So the issue of how much power the federal government or the states will have with respect to slavery. Remember, there are lots of federal territories in this period. The United States has purchased a lot of land. A lot of the area is held as a federal territory before states are created out of it and enter the Union. The federal government takes the position it can outlaw slavery in the federal territories. It's also understood that states control whether they want to have slavery or not once they become states of the Union. So there are a number of issues swirling around this. There's also the problem of fugitive slaves, and the Tawney Court gets involved in all these issues. And so an issue that the Marshall Court's generation managed to avoid, that is, the future of slavery, it is central for the Tawney Court.
Yes, I'm guessing the Marshall Court did not get too much involved in civil rights issues, and I know the Tawney Court, at least from what I read, Justice Tawney believed that, for instance, the infamous Dred Scott decision that's familiar to most of us, that this would help avert civil war to some degree, and in fact it seemed to do precisely the opposite, and shut down debate on the power of Congress to ban slavery. So what kinds of decisions subsequent to Dred Scott with respect to civil rights came up which were momentous?
Well, the Tawney Court assumed that if they could craft a definitive solution to the constitutional issues affecting slavery, that would, as you say, that would sort of stop the agitation. Dred Scott had just the opposite effect. The Republican Party in 1860 campaigned against Dred Scott and took the position that it was going to be opposed to any slavery in any further federal territories.